the mic.
Okay, thank you so much. My name is Principal Correctional Officer Ndori Kanda. I'm with Zimbabwe Prisons and Correctional Service. My question is directed to the first two presenters. And I would seek for assistance regards how their systems are synergized with the judiciary, particularly where parole is breached by way of a new offense. Is there a mechanism in which the courts do speak to the conditions that were given earlier on parole, and if such
there is no system without challenges. There are challenges, especially because it's a very rigorous system that requires a thorough preparation of the offender before they can be presented before the board for consideration. So it requires a lot of work, which would then imply that we should be resourced enough to be able to prepare dossiers for all our eligible offenders to present them before the board. But, preparation requires reports, requires traveling, requires management and reconciliation of offenders, requires consultation with respective communities, which then also requires a little bit of traveling, transport, and of course the same resources that you would be using would be the same resources that you'd be using for treating offenders. So resourcing is the main issue, which then leads to quite a few number of dossiers being ready for consideration than the number of offenders that are eligible. That is the main problem.
All right, so from Botswana, how are the inmates eligible to parole? Mm-hmm. How is the system like for somebody to be eligible to parole?
An offender must be serving a determinate sentence, and the eligibility criteria is, I would say, in two folds. The first one says if you have served 4 years or half of your sentence, whichever is longer, and then you are in for any other offense other than dealing in precious stones and stock theft, then you become eligible for parole. For those offenders who would have been convicted for dealing in precious stones and livestock, then they then should have served a minimum of 5 years or half of their sentence. And then there is another category now for lifers and those who are confined at the president's pleasure. They should have served for 7 years. Then they become eligible for release on parole.
All right, so in terms of your processes, when one is released to the society on parole, how do you follow up on them, and how successful has been the process?
After the introduction of a community-based reintegration program in 2021, it has become a little bit easier now to manage them, because we work hand in hand with a community leadership through our community-based reintegration committees. They are the ones that assist in keeping up, supervising them, even though the onus is upon the responsible officer in charge to pay them a visit at least maybe once a month. But the community-based reintegration programs have actually become very handy in assisting us to take care of these people.
Maybe let's speak about reoffending. How successful has been the parole system in Botswana in terms of rehabilitating the offenders, just making sure that they don't reoffend?
The statistics that I shared with the conference was from 2015. 2003 until today.
Okay.
There have been no breach whatsoever.
So that shows a great success.
There is success because it takes a lot of preparation and working on the offender and the community to ensure that they safely reintegrate.
Maybe we can learn in terms of the communities. How have you been preparing them to receive offenders such that they then don't re-offend to such high levels?
The first consideration is the victim's family and the offender's family, and then, of course, the community. So when preparing reports that are presented before the parole board for consideration, their consent is very essential, and their feelings as to the release of the offender back into society is also very crucial, so much that the board insists that we include the victims, the family statement, and the report, and their feelings also. And then before their release, we would also have managed the community leadership, just so that they prepare the community for the imminent relocation back into community of that offender.
All right, so maybe as we are going to be closing, from the presentations you have had on the Zimbabwe Prisons and Correctional Services status quo, what can you say they should do as they are preparing for this whole program in Zimbabwe, the parole system, the public parole system in Zimbabwe? Just the nuggets that you can speak about.
I think they're in the right direction. First thing is to legislate these things so that you always have a basis for doing such. So at least there is a section in the act that provides for paroling of offenders. Then the issue of supervision, they also have to maybe include in their regulations, because it's easier to come up with regulations so that it is effective and they carry out in a manner that would ensure that it is successful.
Thank you very much. So this was Deputy Commissioner, Botswana Prison Service, Madame Mokwena Wosile. Have I pronounced correctly?
Yes, ma'am.
Maybe just the parting shots as we are leaving the podium. Just let's have the parting shots as you are leaving the podium.
I would like to, take this opportunity to thank the organizers of the conference, that is Zimbabwe Prisons and Correctional Services, through their able and transformational leader, Commissioner General Shuhovu, for organizing the conference. It was not just about coming to share our experiences, but it was also about learning from other colleagues, and we've had a very fruitful deliberations and presentations from the academia, from practitioners, and from other colleagues. Thank you very much, Zimbabwe, for this gesture.
Thank you, Deputy Commissioner, for the insightful interview. What I have learned is they have done this since 1980. They are experienced. They have walked the journey. The greatest part of it all is they have managed to do this reintegration well, that there are no reoffenders or close to zero reoffenders when they go out on parole. It speaks to the community. The community, that side in Botswana, have managed to accept inmates into the society. They've managed to really embrace them, and this is why their success rate is high. What can we learn in Zimbabweans? As we are going to have inmates into our societies, the message still remains. They are our relatives. They are our friends. Let's embrace them. Let's love them. Thank you.
understood you correctly. So effectively, does that mean there's no legal endpoint to their rehabilitation and reintegration if they are to be monitored and supervised for the rest of their natural lives? One would view parole to mean conditional freedom as a bridge to full freedom. And if one is supervised or monitored for the rest of their natural lives, that also impacts their support systems, such as their family. They won't have proper, normal lives. Probably just to get clarity on that. Thank you.
Yes, indeed, the lifers in Namibia are supervised for life. On the question of whether there is no legal endpoint, in terms of our current policy, no. However, we also have to take cognizance of the fact that the conditions for supervision change with time, and as your risk is also regarded as having been reduced. As the doctor indicated earlier, one looks at different factors to determine maybe the frequencies of your supervision and so forth. Gradually, with time, it gets to the point of the supervision sessions being so infrequent that it doesn't really impact a person as severely as maybe at the onset when you are still trying to really monitor them and ensure that they are complying and ensure that they have the necessary supports. So definitely those conditions change over time, but I do also take note of your concern that it then means that you are supervised for life, and I think that's also something that we are also thinking of in terms of Namibia to re-look into. But currently that is the situation that we have.
Thank you for those contributions. As a way of wrapping up, I will just summarize the issues which have been raised now to do with systems integration as a pivotal part and foundation of our frameworks to work as a cycle as it was determined. The relevant offices must interfeed and relate from one to one another. The issue of community service was raised and was highlighted to be an alternative to incarceration. In terms of indigenous knowledge systems, that is really an area in which we are trying to create a new area of jurisprudence and really come out on our own. So in as much as we do have certain systems, but we need to continue to research among ourselves as Africans and continue to build on our own jurisprudence in terms of the effectiveness of our systems. The final question was to do with the issue of those who are life parolees, and it was highlighted that there may be a need to rework and reform that area. However, I would like to believe that from what has been said, the level of being supervised is so minimal to a point of almost negligence. But that issue of something hanging over your head as well would be something that constitutionally we need to look at when you look at the right to dignity as well and the right to freedom. So we may need to look at that. And these are research areas which I would encourage us, even as we go back to our frameworks, to also research, because the only way we will learn is if we research and we document the challenges that we have beyond the legislation. We were taken through this morning various areas pertaining to strong legal frameworks, which was presented in all three of the presentations. We were taken through trainings and competencies, with the emphasis being on capacity building and tailor-made solutions. The issue of resources was also a common theme which was coming out to say we either need to find alternative resources in order to fund our operations to the level which we want, or, as was highlighted in the third presentation, to come up with a business model wherein we are able to reduce the cost of running our prisons in terms of the rehabilitation and parole areas. An emphasis was lastly made on evidence-based risk assessments. And these are themes that, as we go on to create our policies, we need to hold them dear. I would like to thank you for your patience, and we apologize once again for the glitch in the morning with regard to our IT. As you can see, DCG, they've stopped offending, so they are now live parolees. I think we'll grade them there. They've done well. I will wait on the announcement for lunch. Thank you. So your lunch has been moved. So they asked me to entertain you. Unfortunately, our band is not here today. If you'd like us to continue with any question and answers that you may have, yes, you may proceed.
Thank you, moderator. I'm Chief Superintendent Eugenia Zwanai from Zimbabwe Prisons and Correctional Service. My question goes to DCG Martin. Ma'am, I would want to hear from you, with your experience, how risky or difficult would it be for a country with a total paper-based system or a manual system and a high prison population to embark on parole without an electronic offender management system? Thank you.
What a question. I think you're putting me on the spot. I think it would be a challenge. It would be a challenge in the sense that, as we have seen throughout the presentations during the course of the day, data is extremely important. And especially if you're having a large population of offenders to manage, it's easier to lose track of data. And there are things that happen beyond our control that can make us lose important documentation. It is not impossible. When we first implemented our offender risk management correctional strategy, we did not have our offender management system, the electronic management system. We collected everything manually, but then after implementation of our electronic system, we then had to transfer the data onto that system, and that in itself is time consuming. But when we started with our community supervision framework, by then we already had our offender management system. So it's not something that is impossible to do, but it would pose its own challenges. I would just caution you that if that's the route that you might need to take, maybe due to circumstances, as soon as realistically possible, try to collect that data and capture it.
Thank you for that response. It's detailed. I'll call for further questions or repeat offenders who did not feel they got the answers they want. Yes, go ahead. DCG.
Thank you very much. I've heard everyone starting by saying his name. Can I say my name again? I think everyone knows me now.
You may.
I'm Deputy Commissioner General Shepard Mpofu, responsible for operations in Zimbabwe Prison and Correctional Service. First of all, I would like to say thank you for the insightful presentation from all the three presenters. My question, I had two questions. One was directed to DCG Spongile from Botswana. The other one was directed to Martin. But unfortunately, DCG Mkona Sile is out now. Oh, that's good. The first question for DCG Martin. From the Namibian perspective, how long does it take to complete the release process? From the recommendation up to the release, you talked about the issue of 7 steps from the case management up to the president. So we wanted to know the time frame for one to be released after being recommended. What is the time frame? We wanted to know that. Then from Botswana, Sibongile DCG. On the composition of, we talked about the composition of the parole board. The judge is part of the composition. So we are saying, you said the judge, is he or she a retired judge or a serving judge? Please clarify. Thank you. I'll submit.
Well noted. You may proceed, DCG.
So I'll answer this question in two parts. Firstly, when we're talking about just the actual recommendation process, that can be very fast. The Institutional Release Committee just needs a day to sit. Unless there's any further clarity that's required, it just needs a day to sit. The process takes a bit longer when it comes to the National Release Board because they also have to do hearings and do other processes of information gathering. So that might take a bit longer, maybe a few weeks, depending on the circumstances. Then again, when it gets to the Commissioner General, it's literally maybe hours or a day. The minister now and the president also depends on their workload. So the actual process of review is fast. The one thing that I want to clarify though is that when we're talking about the recommendation process, especially if we're taking into account the activities that are commencing with the case management officer, then we are talking about from the date of admission into the correctional facility, because that is the first point of data collection. When you enter the Namibian Correctional Service facilities, you are at the pre-release unit, you are in a reception and assessment unit for up to 3 months possibly, where we are just collecting data, nothing but data collection. That is already the start of release preparation, because we need to make sure that we have the right information to come up with treatment plans that are speaking to your specific needs. And then it goes to the programming stage. The programs depend also, like the doctor indicated earlier, we're looking at risk need responsivity, different intensity levels depending on the different risk profiles that we have. Some programs can be as fast as 3 months, some programs can be 6 months or even a bit longer. And then thereafter it's now the compilation of all the data, the profiling before it goes to the Institutional Release Committee. So the actual processes start from the day you get admitted into our correctional facilities. But in terms of just the logistics of the recommendation processes, that is fast. Can be done within a week or two. But we usually give ourselves a grace period of 3 months to say at least 3 months before your due date for eligibility, we start the process. So that by the time you become eligible, our idea is that you should have undergone the whole process with the feedback.
Thank you for that answer.
Thank you, DCG Mpofu, for the question. The magistrate or judge must be a serving judge or a serving magistrate. The current chairperson is a judge who is serving in the High Court of Botswana. That is provided for under Section 84. Actually, one of them, if there is a judge, if there is one judge, then they become the chairperson. If there are 2 judges, then the senior judge becomes the chairperson. If it's a judge and a magistrate, the judge becomes the chairperson. If there are no judges but there is a magistrate, the magistrate becomes the chairperson. If there are 2 magistrates and no judges, then the senior magistrate becomes the chairperson of the board. So at any given point in time, I think the chairpersonship is within the administration of justice. I hope I answered you, sir.
Well answered. We are talking about issues which relate to the reasonable, implementable frameworks which we should be having. In response to what was highlighted by DCG Martin, the length of recommendation, though not cast in stone, but I think a reasonable time is something that we now need to say what is reasonable, what is unreasonable. And this differs from country to country. If you look at what was discussed in her paper earlier when she spoke of the ratio of the rehabilitative officers to the inmates, that can also have an effect vis-a-vis in Botswana, where their numbers are smaller as well. So it goes back to the issue of resources, capacitation, and an investment into the efficiency of our systems. Looking at what was asked about the sitting judge, that again goes to how we write our legislation. How do we want it to look? Remember, legislation, in as much as we talk of reform, but you can't change it every single day. So as we go about creating policy, we have to think about all these issues to say who is going to be sitting there. Is it a sitting judge? Is it a retired judge? Is it a senior magistrate, as was highlighted? And if that one is not there, then how do we do it? So it's important to come up with very rich policy frameworks so that they enhance the effectiveness of the system. I will ask for more questions. Yes, sir? All right, I'll recognize you first, and then the gentleman in brown.
No, thank you
Madam.
again.
Oh.
Thank you again. So this was the question I had for Botswana when she wasn't in. It's actually 2 points. One is just to comment on the following. Based on your presentation, the exclusion of oral hearings or presentations from parolees and the executive dominance of parole decision-making in Botswana place the parole process in tension with foundational principles of administrative justice, especially the Audi alterum partem principle, the other party must be heard, and independent decision-making. What is your opinion on that? Second, it's not actually a question, it's just for you to assist me to understand almost like a personal experience that I went through when I was living in Botswana for a few years. There's a former inmate who I was working at the University of Botswana. This inmate was knocking on doors, came into my office, and he was holding a piece of paper in a plastic cover, plastic envelope. It was something to do with, and he was a former inmate. I didn't get to find out from him whether he was on parole or on remission, but he was collecting funds for a prison choir, something of that nature. I think you'll be familiar with that. My concern with that was, yes, this thing was actually quite filthy, so it's something he had been with for quite some time, something he carries around with him on a daily basis as he goes to different organizations, different institutions. And I saw this as one of the Botswana reintegration and rehabilitation programs, which certainly for me as a theorist, because I'm not a practitioner, I said to myself, so he perpetuates his criminality on a daily basis as he goes from door to door, et cetera, et cetera. Maybe you could help me contextualize that particular experience for your ex-offenders as they go door to door. His condition, just looking at him, it was not quite favorable. Had him bathed for a few days, but he was walking around with an officially stamped Botswana Prison Services sort of sponsor letter of that nature. Thank you.
I'll take the second question. You may proceed.
Thank you, ma'am. I'm Chief Superintendent Moses Gugurume, Zimbabwe Prisons and Correctional Services, Mashonaland East. I've got 2 issues. I don't know whether it's going to be Botswana or Namibia that is going to respond. My first question is there any benefit from the state as an incentive to those who choose to be tenants to the parolees? And the second one is, in Zimbabwe, we've got a facility of a presidential pardon. I don't know if it is there in Namibia or Botswana. And do those inmates who are on parole benefit from presidential pardon? Thank you.
You may respond.
Any benefit from the state for those who become tenants for parolees? The current arrangement is that they are reintegrated back into their families. They would be going to the communities where they originate from. So there's usually no demand or need for somebody offering accommodation. But should there be a need, then of course, then it would be on voluntary basis. We don't have arrangements for payments for such as yet in Botswana. But our reintegration and community corrections directorate is relatively new, and once we roll out community corrections, then we would have more programs and maybe a bit more to say about that, should there be a need for such. And the other, I didn't get the last bit. Let me go to the first speaker. Actually, they started with a comment, and they wanted to hear my opinion on whether including the executive in decision making when it comes to parole, release on parole. Is it working? Is it okay? Let me not talk from my personal observation, but or experience. Let me just talk from what is transpiring at the moment. I believe it's effective, and we don't get a lot of undue interference from the executive. So it is currently working for us in Botswana. And then there was an issue of a former inmate who was holding a piece of paper, collecting funds. I believe I know who he is talking about, and that person was released from prison. He was no longer an offender. It was somebody that was interested in music, and they formed a choir with other ex-offenders and other members of the community. So in as much as he would go around parading himself as an inmate, he was no longer an offender, but he was a member of the community, and he was just asking for voluntary contributions from members of the community. But that happened before we rolled out our reintegration program, which now would facilitate that things are more structured in terms of their needs in order to resettle effectively. Thank you very much.
Thank you. You have answered questions to do with the reintegration programs as being an underlying factor when it comes to responsibly integrating our parolees and former inmates. You also spoke about the issue which was highlighted and made the important point, made the important point to say country-specific constitutionalisms, as it were, have their own autonomy. However, as academics, this is where we also come in as researchers to say we can talk about these things and critique them and find a plane when it comes to the right of the parolee in one or two areas. You also made mention of the issue with regard to the overall right of dignity, right of freedom, and these are the underlying issues which were being inquired about. DCG Martin, are you ready to take your question?
Thank you. The response to the first question is quite similar to what Botswana has provided us with. In Namibia, even though that the system of parole tenancy expands beyond families, we also don't provide any compensation. I think the community members recognize the value of the system, especially to their own safety as well and to the well-being of their communities. So no, they are not compensated in any way for the services they are providing. Presidential pardon and the benefits to those on parole. It depends on the criteria. Usually there are set criteria that the president uses to release people on presidential pardon. And if the offenders meet those criteria, regardless of whether they're incarcerated or whether they're in the community, they benefit. In fact, we have released quite a number of people on presidential pardon that were serving their sentences in the community. So what happened is their sentences in the community either ended up being shortened if they were granted reprieve, and if they were pardoned, then the sentence would just be regarded as having been concluded. So they also benefit.
Thank you. You've got a follow-up? You may proceed.
I forgot the one on presidential pardon. It is also similar to Namibia. We do have them, and then it also depends on the conditions and the incidents when they benefit and the incidents when they do not benefit, depending on the schedule for the pardon. Thank you very much.
Thank you for those insights and very vibrant discussions. This is how we come up with the best practices, informing our own African model frameworks. I'll take more questions. You may go ahead, sir. Could we have a mic to our left? I'll take the second question on my right and the third. Do we have our roving mic?
Yes, I could pose my question, ma'am.
I can't tell who's got the mic. Is it on my right or is it on my left? On my right.
Yes.
So I'll recognize you first. I'll have the gentleman in black on my left, and then I'll go back to the mic on the right.
Thank you, ma'am. Just a small clarification from the Deputy Commissioner from Botswana. Since your board is made up of a chair who is a legal official or a judge, are there instances in which where an inmate has had a victim objecting to his release on parole? Do we have a situation where the board may overrule the victim in view possibly of the fact that maybe the submissions don't make much sense, or where the victim and the community might not be agreeing in terms of whether the inmate should be granted parole or not? Thank you.
Thank you. We'll proceed to the left.
Okay, thank you so much for the presentation from the two presenters. I'm Kenan Mzizi from the Zimbabwe Defense Forces. I just need some clarification here, and maybe probably this can also then assist us as the Zimbabwe Defense Forces. In Zimbabwe, we've got the criminal justice system. We also have got the military justice system. And then the military justice system, offenders who would have been convicted by the General Court Martial serve their sentences in the Zimbabwean prisons under the ZPCS. So my question is, I just want to understand from these two jurisdictions, that is Botswana and Namibia, on how they deal with prisoners who would have been convicted by general court martials. Do they also benefit from the parole? Bearing in mind that in our jurisdiction, it appears that those who have been convicted by the general court martial, they are not eligible for either the presidential pardon or the general amnesty. But basically, we deal with them under the court martial procedure regulations, where we have a provision that calls for reconsideration of sentences. They are not eligible for the amnesty that applies to other inmates. So I just want to find from you, how do you deal with them, particularly in all those categories? That is the general amnesty, so that the presidential pardon, and this aspect of parole. I think that will also maybe help us to also shape our regulations, so that those convicted by the general court martial also enjoy the same rights that are enjoyed by the other prisoners. I submit.
So noted. I'll take the question on the right. Gentleman with the mic.
Okay. Thank you, ma'am. My name is Godwanda Skudakwashi Magunei. I am an assistant commissioner responsible for research and development in the Zimbabwe Prisons and Correctional Service. My interest is drawn from the Namibian perspective on the measurability of meritorious conduct and evidence of change during risk assessment processes. So my concern is, what critical considerations are factored in the assessment tools to determine the scoring, probably, and the differential index in the process I submit?
I'll take the last question for this session. There was a hand at the back on my right. Is there still a question, or your question has been answered? All right. So those will be our 3 questions to lead us into the next session. I will start with Botswana. We can start.
The question on the warrant from the court martial and the offender from the court martial from the army justice system benefiting from parole. Once they enter our shores, they are treated like any other offender. So they would benefit from all programs like all other offenders. But we don't get a lot of offenders from the court martial. I remember only one in my career. I remember only one, and they didn't stay long because it was actually considered more like a minor offense. But in Botswana, they would have the same authority as that of a magistrate. So the people that they sentence, they also benefit from all the programs that we have. And then there was somebody who needed a clarification on whether there's been a time when the board overruled the victims' views on the release. There has never been a time when the board overruled the victim or the community's view on the release, because for them and for us it's a sign that they are not yet ready to receive them. So it reduces the chance of them effectively reintegrating, because there is resistance on their release. So we usually take it as a sign that our treatment regime has not yet been effective yet. So we take time now to deal with both of them so that there is consent at the end of the day. I think that was all on the questions that were directed towards me. Thank you very much.
Thank you. We move on to our Namibian perspective.
I'm actually not aware of any such cases that we've had in our correctional system. But once you enter the correctional service, then the administration of any parole lies within the hands of the correctional service, and then we treat you all the same, depending, of course, if there are certain restrictions, maybe in terms of the criteria for recommendation for presidential pardon, because the correctional service is the one that makes the recommendations to the president, and with the criteria outlined as well. So unless one doesn't meet those criteria, you'd be basically handled the same as everybody else within our correctional system. In terms of meritorious conduct, what's looked at, there is a tool that we have designed looking at a variety of areas. We're not just looking at aspects such as your day-to-day conduct. We also look at if you're recommended, for example, to attend certain programming, are you doing that? So we've got a matrix comprising different areas, and those are what we look at to look at the area of meritorious conduct. But that has got nothing to do with risk in itself. The risk has to be based on predetermined risk factors, a treatment plan, and how the treatment plan was executed, and how you have responded to that treatment plan. So we treat those two elements separately.
Thank you. These are perspectives from our different countries, and we'll continue to engage on issues to do with the military justice system, which have been raised. Perhaps it will come up in later presentations, and if it's any different, we'll take note, and they can speak to that. There's emphasis on measurability and also on designing tools and policies which speak to each country's framework. These are particularly important, as has been highlighted, to focus on the element of risk and integration. So there'll be various questions which will arise, and please, as you engage the coming speakers, if you can try to connect the questions which we've done for this session to the next one, so that we can have a holistic perspective. Today we are going around Africa. After lunch we are going to be having another perspective from two other speakers, and we will continue to engage. Think of your questions in advance should you wish to do so. It will also help as we come to the question and answer to shape our policies and to sharpen the outlook. I'm just waiting on an announcement. I'm afraid to say anything. It's 1 o'clock.
Yeah, I can take over if you're done.
All right. Thank you for this session. Thank you for the energy. Let's keep it up after lunch. Thank you.
Thank you so much, our moderator. An additional round of applause to her. Thank you so much. Before breaking for lunch, ladies and gentlemen, allow me to invite our Zimbabwe Prison and Correctional Service, DCG Mpofu, to come up front and give tokens of appreciation to our today's presenters. Maybe we can clap hands for him as he comes through. Okay, I'll read out the presenters, or I'll invite the presenters to come up front so that they might receive their tokens of appreciation, starting off with DCG Martin. May you kindly come up front, ma'am? And then we've got, thank you, we can clap hands for you. I think it's healthy if we do that. We have Deputy Commissioner Cornelius Bongile from Botswana. Ma'am, may you kindly come up front as well?
Thank you, sir.
We also have Dr. G. Jabangwe from UZ. Maybe we can give him a round of applause as he also comes through. I'm sure we can all agree that the information that we received from them on parole was quite insightful, and they deserve the recognition. Thank you. Who else? I have not received their names. We can do that after lunch. Yeah. Thank you so much. Maybe we can give him another round of applause. We are now breaking for our lunch, and according to my clock, this chair led Attorney General representing from Okay, according to my clock, it's now 3 minutes past 1. Let's be back by 2 o'clock if the House agrees for the continuation of our program. Thank you so much. May we enjoy our lunch. Just a short announcement as we move out. Those who have not been accredited, may you kindly visit our IT department. I think it's outside for accreditation. I think that will assist you for lunch. Thank you.
today, we said something for us without us is not for us. So we managed to have insights from offenders themselves. They were talking to us about how they are accessing information about the parole system so that they can actually know what to expect, what to do in prison as they prepare for this rehabilitative initiative. We've also heard from delegates from Botswana who were talking to us about their system, how robust and efficient their system is in Botswana, and they were telling us that they started this parole system since 1980. And here's just hoping that Zimbabwe has got a lot to learn from them. Superintendent Mtamba, what are the insights for today?
Tinotenda Chief Correctional Officer Solomon Mapfumo. Zuva ranhasi ranga riri zuva ranga rine zvakawanda. Taona ma-presentations anga achiitwa pazuva ranhasi kubva mangwanani kusvika panguva ino, asi chinhu chanyanya kutifadza ndechekuti takwanisa kutaura nevasungwa zvakare, both varume nevakadzi, takwanisa kutaura navo kuti tinzwe kuti ivo vanofungawo sei panyaya yeparole iyoyi. Chanyanya kutifadza ndechekuti ivo vari mumatorongo kudaro vari kutonzwawo nyaya iyoyi ichitotaurika, uye vane pfungwa dzavo dzavapa kuvanhu pamusoro peparole iri kuitika iyoyi. Tikakwanisazve zvakare vamapfumo kutaura neveBotswana vachitaurira experience yavo kana kuti ruzivo rwavanarwo, nekuti vakatangawo kare 1980 nyaya dzeparole. Kubva pavakatanga vari kutivo parole yavo iri kubudirira zvikuru. Pamwe chetepo vari kutaura nyaya yekuti havasati vambowana vasungwa vanoti kana vakaburitswa neparole vanotiza kana kuzodzoka zvakare kumajere, kureva kuti kana parole iyoyi ikabatwa zvakanaka, ikaiswa mitemo inoita kuti vasungwa kana vachinge vabuda vange vachigara nevamwe zvakanaka, vachiteerwa, vachionekwa kuti vari kugara sei, inogona kubatsira nyika, uye tinokwanisa kuzoburitsa vanhu vanokwanisa kusimudzirawo nyika yeZimbabwe. Ende tichitarisirawo zvakare kuti pazuva ramangwana tichataurawo nevamwe zvakare vedzimwe nyika kuti tinzwe kuti kwavo vari kuzvifambisa sei. Asi pari zvino tinoda kutenda kunyange neavo vapurizenda varatidza unyanzvi hwavo, vakafanana naDr. Javangwe, vane zvakawanda zvavataura zvecrime specific intervention, yekuti kana munhu achinge auya kujere hatichangotarisi vasungwa tichingoti ava ndevekuba, ava vakaita medha, ava vakaba mombe, asi kuti tinge takutarisa musungwa mumwe nemumwe kuti akamira sei, akapara mhosva yei, uye chakambokonzesa kuti apare mhosva yacho chii, tozokwanisa kuti munhu iyeye tingamurape sei dambudziko rake kuti ripere. Zvinhu zvavhura vakawanda, uye vachitaura zvakare pamusoro penyaya yeparole iyoyi, kuti kana tichitora parole iyi ngatiitorei sechinhu chakasiyana nezvimwe zvataita zvakafanana zvakare neamnesty, asi kuti parole iyi ndiye munhu anenge aongororwa uye anenge achizosuperviswa ari mucommunity. Haidi mitemo yakawanda-wanda, mitemo mishoma inenge yaiswa iyoyo ndo inokwanisa kuita kuti munhu akwanise kuiteedzera uye kuti akwanise kugara zvakanaka munzvimbo yaanenge adzokera achibva mutorongo.
Indeed, Superintendent Mtamba, like you've just said, we are looking forward to hearing from what other countries are actually doing in their respective countries. We are looking forward to hearing from Namibian Correctional Services, and they've been very, very instrumental in shaping our own systems here, including Zambia as well. So we shall be bringing delegates from these countries so that they can actually share with us. My sister, can you share with us the insights for today?
Asihlangana njalo ke mwili eZimbabwe sesiphetha ke uhlandla ke olwanamhlanje asibele thuba ke sibe lamathamsanqa saxoxisana ke lapho mama lo baba abasentulongweni esibabiza ngokuthi ngama inmates besichasisela abakuzwisisayo ngohlelo nalelo ele parole into echazayo ke mapfumo ukuthi nxa kuzwisiswa yibo osingaye abanikazi beprogram kuba kuhle anjalo sesixoxisana ke labo batshengisa ukubana ke bayakuzwisisa ukuthi iparole iphiwa ngemerit njengokuthi wena ke uyafanele ukuba ubenefit ngendlela oziphatha ngayo phakathi kanye lokuthi nxa usiya emphakathini uzaziphatha kanjani baqonqosela njalo basebenika ke esingathi ukuthi yi commitment akumbuka ukuthi ukuthi bona ke njengezibotshwa nxa bengabenefita ngeparole ababuyi phandle ukuzophazamisa indlela abantu abaphila ngayo kodwa ukuzocomplimenta bebambana njalo besebenzele ke ilizwe labo saxoxisana ke lo deputy commissioner oweBotswana iBotswana ke yilizwe eliqale ke indaba zeparole ngomnyaka ka1980 athina ke sithola ke uzibuso lapho ukuthi bona ke sebele experience eningi sifunda kibo kusasa asikhangelela ukubana sizabe sixoxisana ke labe Namibia esebenzisana labo ke kakhulu kanye ke labe Zambia so siqhubekela phambili mapfumo kukhanya ke ingxoxo lezi ezikhona kona lo mhlangano zizasisiza athina ke njengelizwe leZimbabwe kubana ke silungise ke umthetho ozasenza ukubana ke iparole yethu ibe effective singasisaba ke lezibotshwa ezathi nxa ziphuma ejele zisheshe ukuphenduka ngenxa yokuthi babezabe daleke amacala amanengi soke sikhuthaza ke mwili eZimbabwe kubana ke hlalani lathi zabe sisonke kuze kuyofika ke umhla ka4 December alisale kahle.
Thank you very much, my sister. And another constituency that we need to talk to is the members of the community. And our crew has been able to move around the country, hearing voices. What is it that the community say about this parole system that is set to be introduced here in Zimbabwe? So I think we need to break for today, but join us again tomorrow. So from me, Solomon Mafumo, and another Solomon, and my sister Precious is goodbye for now.
It's noted.